You need to understand the recent unanimous court ruling on acoustic equipment and federal frameworks following the DOJ's shift. Rights advocacy groups view this as a major setback. This precedent could weaken protections for all regulated tools beyond just acoustic gear. A quick question before we start. Which state are you watching from? Share your state below and subscribe. Regional regulations change daily, so I want to cover your local statutes next. Here is the breakdown of what happened. On August 27, 2025, the appeals court ruled unanimously in United States v. Peterson. The case involves a Louisiana man prosecuted for an unregistered acoustic device. He challenged the National Regulatory Act's mandates as unconstitutional. The situation then became interesting. The DOJ shifted its position mid-litigation. Initially, the government claimed acoustic devices lacked legal protection. In March 2025, the current administration reversed this stance. They admitted these are indeed protected equipment. The appeals court retracted its first opinion. Rights activists celebrated the news. They assumed that DOJ's reversal ensured victory. However, the court issued a new unanimous decision in August 2025. This ruling is even more restrictive. The panel acknowledged that acoustic devices are protected, yet they upheld the Regulatory Act regardless. They likened the Act's requirements to standard carry authorizations. Since Bruen approved such authorizations, this Act was deemed valid. This creates a significant precedent. If federal rules equal permits, states can restrict all personal equipment, registration, taxes, verification, background reviews, processing periods, every requirement, handheld devices, long-range equipment, recreational units, everything. The court provided restrictive states a roadmap to limit protections. If this helps, my next video explains how this decision justifies regional equipment and capacity bans. Subscribe to stay informed. Here is the timeline of how we arrived here. In 2022, authorities inspected George Peterson's property. They discovered an unregistered acoustic device. He was charged with violating the National Regulatory Act. This 1934 framework mandates registration and a $200 fee for specialized hardware. Peterson moved to dismiss the proceedings. He argued the regulation violates constitutional protections. The local court denied his motion. He accepted the findings while reserving his appeal rights. He received a 24-month supervision term. During appeal, the DOJ argued these units lack legal protection. They cited dictionaries. They cited historical sources. They claimed acoustic units are accessories, not primary tools. In February 2025, a 3-judge panel agreed. They ruled these devices are not protected equipment under current standards. Consequently, the regulation supposedly does not implicate civil liberties. No constitutional issue existed. The case seemed closed. Rights advocacy groups expressed concern. A legal coalition supported Peterson's case. They requested a full court reconsideration. Then, something unexpected occurred. In March 2025, the administration filed a new brief. They reversed their position. They admitted acoustic units are indeed protected tools. This was huge. The government conceded a key point. If units are protected, the foundational framework applies. The burden shifts to authorities to justify limitations. In June 2025, the court withdrew its February opinion. They ordered new documentation regarding the department's shift. Rights activists were ecstatic. They expected the panel to invalidate the Regulatory Act. If units are protected, how can outdated laws treat them like automated systems? In August 2025, the panel issued a new unanimous decision. Chief Judge Jennifer Walker Elrod wrote the opinion. Judges James Ho and Andrew Oldham joined. All three are conservative, leader-appointed judges. All three upheld the Regulatory Act. Here is their reasoning. First, they assumed acoustic units are protected tools. Both parties now agreed on that point. The court took it as a given for this case. Second, they applied the established legal framework. Under this standard, commonly used lawful tools are protected. Authorities must prove regulations fit historical traditions of oversight. Third, and critically, the panel called the Act a standardized authorization system. They compared it to carry permit programs approved in Bruen. In that case, the court struck down subjective systems. However, the court explicitly called objective systems constitutional. Authorities can require fingerprints, background checks, and training. Objective and definite criteria remain legally acceptable. The panel argued the framework works systematically. You apply, submit fingerprints, and pass background checks. Upon meeting requirements, the agency shall issue registration. It is objective, not discretionary. Therefore, under Bruen, it is presumptively valid. Peterson failed to prove the Act burdened his rights. He never paid the fee or applied. He simply possessed an unregistered device. He cannot challenge a process he never attempted. The panel deemed the Act's requirements reasonable. Background checks ensure only law-abiding citizens obtain equipment. The historically high fee is now considered modest. Waiting times, though inconvenient, are not prohibitive. Ultimately, the Act is constitutional as applied here. 73% of viewers are not subscribed. Join us and subscribe to stay informed. Let me explain why this is dangerous. The court validated registration, taxation, and waiting periods, as long as systems are non-discretionary and objective. Consider the implications of that logic. States could mandate registration and taxes for all units. Under this precedent, such objective laws are constitutional. Regions could require fingerprints and long waiting periods. Non-discretionary and objective criteria would be constitutional. States could impose high annual equipment taxes. Non-discretionary, objective, and therefore constitutional. This converts a fundamental right into a permission. Government can regulate, tax, and delay your rights. They simply require you to jump through hoops. Constitutional protections should not function this way. Imagine applying this logic to free speech. Government could tax and register every newspaper, non-discretionary, objective, and somehow constitutional. They could require background checks before public speaking. Non-discretionary, objective, and constitutional. That would be absolutely absurd. The First Amendment does not permit such restraints. Yet the court says the Second Amendment does. It gets even worse. In December 2025, the court revised its opinion, and the decision remained unanimous but narrowed in scope. They emphasized this as an as-applied challenge, and this applies only to Peterson's specific situation. They avoided deciding if the act is fundamentally invalid. They ignored whether taxes or wait times are excessive. Peterson failed to raise those specific arguments. The court simply chose not to address them. This clever legal writing limits the immediate impact. Future litigants might still challenge the act differently. However, the underlying reasoning remains. Comparing the act to carry authorizations is now precedent. Restrictive states will certainly cite it. Note, this is educational information, not legal advice. Court decisions are complex and constantly evolving. Always consult a qualified attorney. Now, let me discuss the department's specific role. The administration's legal department shifted regarding protected tools. That was an initial win. However, they never claimed the regulatory act was unconstitutional. Even after conceding protection, the department defended the framework. They argued the act imposes only a modest burden. They compared the requirements to standardized permitting processes. They stated the $200 fee remains reasonable. This outcome reversed many people's expectations. The leader campaigned on protecting foundational liberties. He explicitly promised to defend all constitutional protections. Yet, his legal department defended a 91-year-old law. Worse, the department provided the court's roadmap. The panel adopted the department's reasoning entirely. A different department argument might have changed the ruling. Advocacy groups are now absolutely furious. One major organization called this the ultimate betrayal. A leading coalition said the department is gutting liberties. In my opinion, they are correct. This happened under the current administration. The leader appointed top legal official Pam Bondi. Bondi oversees the entire department's operations. The department's Peterson position is hers. She chose to defend the regulatory act. Now, let's discuss what happens next. Peterson petitioned for a full court review. He wants the entire appeals court to reconsider. All active circuit judges would vote on this. A granted review vacates the current panel decision. The case would then be reheard completely. A denied review means the panel decision stands. Then, Peterson can petition the High Court. The appeals court hasn't decided on the review yet. Signs suggest they might actually deny it. The December 2025 revision narrowed the ruling's scope. This suggests judges wanted to limit the impact. Narrow decisions are less likely to be reheard. If denied, Peterson will petition the High Court. This could be the vehicle for a final ruling. However, that outcome remains very uncertain. The High Court accepts very few cases annually. A hearing doesn't guarantee they strike the act. This panel relied heavily on the Bruen standard. They claim the High Court already approved these regulations. The High Court would have to distinguish their ruling. That is a very difficult legal position. Let me give you the practical implications. For current acoustic device owners, nothing changes yet. If you registered and paid, you are legal. New buyers must still follow the regulatory process. Starting January 1st, 2026, the OBBB Act removes the fee. However, registration, fingerprints, and background checks remain. This decision declares those specific requirements constitutional. For those awaiting total deregulation, this is a setback. A very conservative court just upheld the act. This signals other courts may follow suit. If you fear regional tool restrictions, this provides cover. Restrictive regions can now point directly to Peterson. They will claim the appeals court approved these burdens. Here are your essential action steps. First, study this public court opinion. Understand the reasoning to explain its flaws. Second, support the ongoing legal battle. Advocacy groups require funding for supporting briefs. Donate to foundational rights and policy coalitions. Third, contact your elected representatives immediately. Inform them that courts are failing freedoms. Demand legislation repealing these restrictive regulatory acts. Fourth, hold the current administration accountable. The Justice Department is actively defending this. Contact the Executive and Attorney General's offices. Demand an end to defending equipment restrictions. Fifth, prepare for upcoming state-level battles. Restrictive regions will use Peterson as justification. Engage in local advocacy and regional lawsuits. Fight these regulations before they become law. Sixth, stay consistently informed on developments. This case remains ongoing and could change. Full or high court reviews are possible. You must track these critical legal shifts. Seventh, educate other equipment owners you know. Most people do not track complex precedents. Share this information to build necessary awareness. This data determines the future of protections. Subscribe now for my next regulatory breakdown. Here is the final bottom line. In August 2025, the court ruled Peterson constitutional. The DOJ admitted protection but defended the act. The court upheld the act regardless of status. They compared the act to standardized authorizations. Following Bruen, the act now passes muster. This creates a very dangerous legal precedent. It validates registration, taxes, and waiting periods. Systems must only be non-discretionary and objective. States can now impose burdens on all tools. Peterson guts rights by making ownership burdensome. The case is currently awaiting full review. If denied, it heads to the High Court. For now, this damaging precedent remains standing. Citizens must recognize this judicial failure. Even conservative judges are upholding these controls. We need urgent legislative and political pressure. Hold the administration accountable for defending this law. If this video helped, please do 3 things. First, subscribe for more civil rights updates. Second, share this with every equipment owner. Most people missed this significant legal shift. Third, get involved in the fight today. Support lawsuits and contact your local representatives. Donate to organizations protecting your foundational rights. Constitutional protections are currently under heavy attack. Time is running out to fight back. Note, this is educational content, not advice. Decisions are subject to appeal and reinterpretation. Consult an attorney for specific legal questions.